Let's play the who gets the inheritance game when there's no estate plan. And we're looking at one living child and one living grandchild from a deceased child. The answer in just a second, at least in the state of New York. Before I get there, I'd like you to think about a close friend of yours who's struggling with a what-if scenario that creeped into their lives. But they were prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we're going to help some folks along the way. So again, when there's zero estate plan in place, the intestacy laws of that given state where the person resided will apply. They do vary a little bit. Just by way of example, using New York law, I'm licensed here, of course, so I can use that pretty readily. When there is a child and a grandchild of a deceased child, they will each receive something. In this particular circumstance, the child will receive 50% and the grandchild will receive 50%. Now, this is called distribution to the heirs, or issue really. They call it issue by representation. Now, if the deceased child in this circumstance had multiple children, that by representation piece still says, okay, if all the children were still living, right, they each get a share. But because that child's not living, their share gets divvied among the children that they had. So 50% would go to the living child. And if the deceased child had 3 kids, right, the other 50% would go to those 3 children. It does vary by state, so you have to check the law where the decedent was. So we hope you've learned something new here today and that you choose to share. It's very important. We want others to learn so they can be knowledgeable and protect themselves and their family. As always, from the bottom of our heart, we hope you take care.